Africa, the National Publicity Secretary of the All Progressives Congress. This afternoon, I'm here with my colleagues, Professor Abdul Karim, to offer some clarification regarding the decision of the Court of Appeal on the Kano gubernatorial election. You may recall that on the 17th of November, the Court of Appeal handed down a decision in the appeal that was brought before it, nullifying the election of the governor of Kano State, Abba Yusuf, of the New Nigeria People's Party, and affirming the election of the candidate of the All Progressives Congress, Nasiru Gawuna, as the validly elected governor of Kano State. In that decision, the Court of Appeal affirmed the legitimate will of the Kano electorate as expressed at that election. However, there's been trending reports in the immediate news cycle regarding what appears to be some confusion on one or two paragraphs in the certified true copy of the decision that was released, which error or mistake or typographical error has since been rectified. Now, I will yield to my colleague, Professor Kano, the National Legal Advisor, to offer some comments in clarification of what happened. Thank you. Thank you very much.
And we're confronted with media reports from different news outlets, mostly print media, and a few social media platforms where a controversy was identified in the released certified true copy of the judgment of the Court of Appeal that was delivered on the 17th of November 2023 here in Abuja by the appeal panel that was constituted under the chairmanship of my Lord Honorable Justice Muri Asemo Abraham. It ordinarily wouldn't have been a confusion if it was probably not a political matter, because it will not be the first time that such typographic errors may emerge on the face of a released CTC of a judgment. And being lawyers who may be used to a situation like this, all that is done is to merely correct that mistake. The most important thing is the judgment that was read in court to the hearing of the whole world on the day of the delivery of the judgment. And we all knew the findings of the court and the reasoning of the court, which was to the effect that the appeal lacked merit, and then the judgment of the tribunal, which was delivered on September 20th, 2023, was upheld. And then if you read through the entirety of the judgment from beginning to the end, for the points where the court, my Lord, the lead judge, analyzed the submissions of the different sides in the case and made appropriate findings, it gives you an idea what should be the conclusion. But that's not all. If you read the concurring judgments of the two justices, because there are three judges who sat over the appeal, the two justices had explained. The two justices had explained and clarified their positions. If you read the findings of my Lord Honorable Justice, let me get his actual name, the judgment of my Lord Honorable Justice Bitrus Sanga, who stated that he has read the judgment of my Lord Honorable Justice Esemo and agrees with him completely, and therefore dismissing the appeal for lacking merit. That explains what he has read, because he said he read the draft copy of the judgment and he agrees with my Lord, dismissing the appeal for lacking in merit. My Lord Honorable Justice Lateef Adebayo Ganiyu also delivered his own judgment, dismissing the appeal. In other words, there were two concurring judgments out of three. They were even clearer, very clear, making it obvious that the last three lines in the concluding part of the judgment of my Lord, the presiding judge, whereby an assertion was made on the CTC, not as read in the open court, finding merit in the appeal and imposing 1 million naira costs on the first respondent, instead of the appellant, was clearly and obviously an error. And then, in a situation like this, for us lawyers, what we do is that we'll do a community reading of the entire judgment to see what exactly is the finding of the court. For anyone who reads the judgment from page 1 all the way to page 72 of the judgment, you will agree that most certainly that assertion, those words, instead of upholding the judgment of the lower court, it says setting aside the judgment of the tribunal, was definitely a typo. So I don't think the explanation needs to come from us, but for us, we can only render our own perspective as a part to the entire imbroglio that is going on. But as to the explanation as to where the error happened in the course of typing the judgment, it is for the courts to provide explanation. I'm sure they will have done that by now by taking necessary measures to issue a fresh CTC which contains the accurate and appropriate judgment of the court. So for me, I don't think, as it is right now, there's any confusion as it were, except those who would prefer that we will continue to see it as a confusion. Thank you very much.
Thank you.
SYMFONI is just one of the thousands of other lawyers in Nigeria. As far as I'm concerned, he's a very senior lawyer by all means, and then he may have rendered his view on what he thinks should be done, but that's his own view. And as far as we are concerned, there is a perspective to it for which we have rendered ours as a party, and we are also lawyers. And in our ranks and file, there are also senior witches of Nigeria who have also gone through the CTC of the judgment and set it side by side with what we recorded. Get a copy of what you recorded live during the delivery of the judgment with what appeared in the CTC, and you will know what was in the mind of the court, what exactly the court may have decided upon. Assuming but not conceding that after all the reasoning that were made, throwing away and throwing out all the positions of the NMTP in the judgment, at the end of the day reaching this conclusion, don't forget there were 3 judges. By our jurisprudence, where there are 3 judgments, if 2 of the judgments were for and 1 is against, the majority carries the day, isn't it? We have 3 judges, and out of the 3 judges, 2 of them have rendered their own judgments, dismissing the appeal and upholding the finding of the election tribunal. So in the worst scenario, whereby probably the conclusion of the lead judgment is to the effect that the appeal had merit and therefore upheld, perhaps. But don't forget there are 3, and we had 2 other justices who concurred and agreed with the submissions of the respondents, particularly the first respondent, the NNP, or the APC, whereby the appeal was held to have lacked merit and therefore was dismissed, and upholding the judgment of the tribunal. So as far as I'm concerned, we do not interfere with judgments. We do not interact with justices once cases are on. And you may have noticed, in my capacity and my office, as the National Legal Office of the party, we have done everything possible to avoid interacting with the press during this period of the cases, because as far as we are concerned, when cases are on and ongoing, counsel, the general public, must avoid discussing issues that have already been submitted to the courts for deliberation. In law and by our ethics, it is wrong. And that's why we've avoided it. And as a party, we've ensured that we guided the party to avoid anything that would appear as if they are attempting or even trying to interfere with the proceedings in court or with the activities of the justices who preside over some of these cases. So if you read the whole of that case, the judgment, even the CTC as it is, from beginning to the very last page, it agrees with our case, just in 2 or 3 lines. So if you were to suspect that someone had attempted to interfere with the production of the certified true copy, who would you suspect? If a judge, out of 72 pages, in 70 pages, has said your case lacked merit, and in the conclusion, he now says, I will hold your case, in just 1 or 2 lines, who will you suspect may have interfered with the content of the production of a produced version of the CTC? Who would you suspect? But I wouldn't want to create a situation in which a fresh controversy will not be opened. As far as we are concerned, we view it as a mere typographic error on the part of the court when it was typed. The justices are under intense pressure. This is a 72-page judgment that would have been prepared after going through probably 10,000 page submissions from different lawyers, the different sides, from the appellant side to the respondent side, the brief of arguments, the records of proceedings. These justices were expected to go through it within 1 month. Within 1 month, and deliver a judgment. Okay. So you would certainly at some point, and I think the way I view it is that this is an error that has been made on their part, and it will not be the last because of the kind of pressure the justices are under.
Just before you, was not about this specific issue. Mr. Falana was commenting rather on the substantive aspects of the case regarding the ballot papers that were validly excluded by the court. That was his comment. And on that question as well, we completely disagree. There's a reason that the law requires for ballot papers to be authenticated, so that only legitimate valid ballot papers are cast and counted by INEC, rather than a situation where you can just bring ballot papers from anywhere and dump in the ballot box and count when in fact they're not legitimate ballot papers. So, if you argue that the electorate should be penalized for the mistakes of INEC, I don't agree. It's not about penalizing the electorate. It's about ensuring the integrity of the votes and the counts that is made before the collation and declaration of result. Yes.
Yes, sir.
Don't you think that we need, sir, for the party to formally
receive officially? My office has not received officially a certified true copy of this judgment. Officially. The copies we have are the same copies that you have seen on the social media. It is possible that the court may have discovered its mistake by now and taken necessary measures to correct it. So what we will do and what we have done right now, or rather what we have done now, is to write a request, an application to the court for a CTC, until the copy is officially conveyed to us containing that error, which is being bantered around, before we now know what to do next. But I will suspect that whoever may have received a copy of that, which is circulated containing that error, if he was an appropriate person, entitled to a copy, we'll have taken necessary steps to ask for the court to seek clarification on it by now. But I would suspect that the court should have taken necessary steps to make corrections. But as far as my office is concerned, we have not received an official copy of the satisfactory copy of it yet. All this we have, that's why you can see me looking through the phone. I have not received, but we'll write and get copies. If the copy that will be conveyed to us eventually still contains this error, it is then we will take necessary steps. Yes.
Thank you. Thank you very much. So that will be...
Thank you.